So the Foreign Investment Act of 1991, or the Republic Act 1742. The policy of the law. The state shall attract, promote, and welcome productive investments from foreign individuals, partnerships, corporations, and governments, including their political subdivisions, in activities which significantly contribute to national industrialization and socio-economic development to the extent that foreign investment is allowed in such activity by the Constitution and relevant laws. Foreign investments shall be encouraged in the enterprises that significantly expand livelihood and employment opportunities for Filipinos. Enhance economic value of farm products, promote the welfare of Filipino consumers, expand the scope, quality, and volume and exports and their access to foreign markets, and or transfer relevant technologies in agriculture, industry, and support services. Foreign investment shall be welcome as a supplement to the Filipino capital and technology in those enterprises serving mainly the domestic market. So, as a general rule, there are no restrictions on extent of foreign ownership of export enterprises. In domestic market enterprises, foreigners can invest as much as 100% equity, except in areas included in the negative list. In this case, foreign-owned firms catering mainly to the domestic market shall be encouraged to undertake measures that will gradually increase Filipino participation in their businesses by taking Filipino partners, electing Filipino to the BOD, implementing transfer of technology to Filipinos, generating more employment for the economy, and lastly, enhancing the skills of Filipino. So basically, Foreign Investment Act, or the FIA, is the law governing foreign investments in the Philippines, irrespective of the nature of the business and area of investment. The FIA spells out the procedure by which the non-Filipino nationals can invest in the Philippines. In the important terms in FIA, first is, what is a foreign investment? A foreign investment is an equity investment made by a non-Filipino national, meaning an alien or a foreigner, in the form of foreign exchange and or other assets actually transferred to the Philippines and duly registered with the central bank, now the Bangko Sentral ng Pilipinas, which shall assess and appraise the value of such assets other than the foreign exchange. Second important term. So we go with the definition of doing business. This includes soliciting orders, service contracts, opening offices, whether called liaison offices or branches, appointing representatives or distributors domiciled in the Philippines, or who in any calendar year stay in the country for a period or periods totaling 180 days or more, participating in the management, supervision, or control of any domestic business, firm, entity, or corporation in the Philippines, and any other act or acts that imply a continuity of commercial dealings or arrangement and contemplate to the extent the performance of act or works or the exercise of some of the functions normally incident to and in progressive prosecution of commercial gain or of the purpose and object of the business organization, provided, however, that the phrase doing business shall not be deemed to include mere investment as a shareholder by a foreign entity in domestic corporations duly registered to do business, and or the exercise of rights as such investor, or having a nominee director or officer to represent its interests in such corporation, or appointing a representative or distributor domiciled in the Philippines which transacts business in its own name and for its own account. As for export enterprise, it is an enterprise which produces goods for sale or renders services to the domestic market entirely, or if exporting a portion of its output fails to consistently report at least 60% thereof. While a domestic market enterprise is an enterprise which produces goods for sale or renders services to the domestic market entirely, or if exporting a portion of its output fails to consistently export at least 60% thereof. Always remember that with regards to registration of investments of non-Philippine national, without need of prior approval, a non-Philippine national not otherwise disqualified by law may, upon registration with the Securities and Exchange Commission or the SEC, or with the Bureau of Trade Regulation and Consumer Protection or the BTRCP of the Department of Trade and Industry, in case of single proprietorship, do business or invest in a domestic enterprise up to 100% of its capital, unless participation of non-Philippine national in the enterprise is prohibited or limited to a smaller percentage by existing law and or under the provision of the Act. Remember that the SEC or the BTRCP shall not impose any limitation on the extent of foreign ownership in an enterprise additional to those provided under the FIA. We have the so-called foreign investment negative list, or the list of investment areas reserved to Philippine nationals. The foreign investment negative list, this is a list ng mga investment areas na para lang sa mga Filipino. So kung hindi ka Filipino, then you should strictly follow the rules on Foreign Investment Act. So the foreign investment negative list has two component lists, the list A and list B. The list A enumerates the areas of activities reserved to Philippine nationals by mandate of the Constitution and specific laws, while list B contains the area of activities and enterprise regulated pursuant to law. It may either be those which are defense-related activities, those that requires prior clearance and authorization from DND to engage in such activities such as manufacture, repair, storage, and or distribution of firearms, ammunition, lethal weapons, military ordnance, explosive, pyrotechnics, and other similar materials, unless of course such manufacturing or repair activity is specifically authorized with a substantial export component to a non-Philippine national by the Secretary of National Defense. Another is those which have implication on public health and morals. Sa list B pa rin ito. So, those which have implications on public health and morals under list B, such as those manufacture and distribution of dangerous drugs, all forms of gambling, nightclubs, beer houses, dance halls, sauna, and steam bath houses and massage clinics. Always remember that in a small and medium-sized domestic market enterprise with a paid-in equity capital less than the equivalent of $200,000 are reserved to the Philippine nationals, provided that 1. They involve advanced technology as determined by the Department of Science and Technology, or number 2, they employ at least 50% direct employees, then a minimum paid-in capital of $100,000 shall be allowed to non-Philippine nationals. Last, the foreign investment in domestic market enterprise. The non-Philippine nationals may own up to 100% of domestic market enterprises unless foreign ownership therein is prohibited or limited by the Constitution and existing law or foreign investment negative list. While in a foreign investment in export enterprise, kanina domestic, ngayon export enterprise, okay? Foreign investment in export enterprise whose products and services do not fall within list A and B of the FIA negative list is allowed up to 100% ownership. The export enterprises which are non-Philippine nationals shall register with the BOI and submit the reports that may be required to ensure continuing compliance of the export enterprises with its export requirements. The BOI shall advise the SEC or the BTRCP of any export enterprise that fail to maintain the export ratio requirement. Also, the SEC or the BTCRP shall order the non-complying export enterprise to reduce its sales to domestic market to not more than 40% of its total production. Failure to comply with such SEC or BTRCP order shall subject the enterprise to cancellation of the registration, of course, including some other penalties.